Welcome back. Again, we're speaking with Mike Canarick, and again, Michael's background is wills and estate planning. And Mike, it was interesting is when we're talking about the purpose of the plan, what should be done, and so forth. There's a lot of documentation that I've seen over the years that people utilize to indicate their intent, what they'd like to have done, and so forth. And for a lot of people, it can be pretty confusing. I remember an attorney years ago used to sit there and go, doesn't pass the weight test, and they would just pick up a document, and you'd have a will that had 2 or 3 pages, and they'd look and they say it couldn't possibly have enough information in there to indicate intent or tax planning. So maybe what we should really do is talk about what are some of the, start with some of the basic documents for basic estate planning people should be considering, and they'll go from the basic documents to maybe a little bit more sophisticated, and for some of the control issues. So Mike, what do you think, and what should we be looking at with that?
Yeah, I mean, as you mentioned, wills are probably the most basic of any estate planning document. And believe it or not, there's a lot that can be accomplished within a will. I mean, I meet with a lot of clients, maybe they're younger and they're just having children, and their sole intent in a will is, we need a will because the will names the guardian. Right. And that's true. The will does name a guardian, and you need a will to name the guardian. Absolutely correct. But the will does a whole lot more than that. And not only does it distribute the assets how you want them to go. I leave everything to my wife, and then at my wife's death, I leave everything to my kids. But you can accomplish a good deal of tax planning in a will. We started to talk about some tax planning earlier. And again, just the tax planning within a will could, depending on the tax laws and depending on your assets, it could be, millions of dollars of tax savings. The will can accomplish a lot of the control that we talked about and the setting up of trusts, and it can be drafted flexibly, and there's so much that you can do within a will other than name a guardian of your children.
What other documents should they be looking at, Mike? Beyond the will, what should they be going into?
Sure. In addition to wills, I think it's every client should have a power of attorney and a living will, healthcare proxy document.
Just give us an overview on what those 2 documents provide, and the benefits of putting those in place.
Sure. A power of attorney is a document where you're appointing somebody else to act on your behalf if you're unable to act for yourself. A quick example from my own personal world. My grandmother has been sort of losing it over the last few years. She's had to move out of her home and into assisted living, and my mom has power of attorney over her, and because of that, my mom is able to write checks on her account to make sure her bills are paid. My mom was able to sell her home. Without that document, my mom has no authority to sell my grandmother's home, and my grandmother has no capacity to sell her home, and it just sits there, and it's a problem. And I think it's important that whenever you do a will, you also sign a power of attorney document. It's a simple document to put together. There's no reason not to do it, and what I find a lot of times is people start looking for power of attorney once the person's mind starts to go and you actually need it, and by then it can be too late. I mean, you need mental capacity to sign these documents. So,
gotcha.
That's a document that should always be done when you're doing a will. And the other document that I mentioned, the living will and healthcare proxy. A living will is a document that expresses your intent in connection with certain medical situations. The biggest one being your intent not to be kept alive under artificial circumstances when there's no hope of recovery. If you remember that Terry Schiavo situation years ago was the big national case that sort of put living wills on the forefront. And in addition, a healthcare proxy, you're naming someone to make medical decisions for you if you're unable to make them on your own. And again,
and it's not that they're making medical decisions just because you're terminal. They could be medical decisions across the board because you could be in a coma, you could be hurt and not be able to to make those.
Absolutely, it's all medical decisions when that person's unable to make them on their own.
And that's a tricky spot to be in. If you don't know someone's intent, what would they want to have done, and so forth. So I think it's great that gives some guidance.
Yeah. So those are the big 3: wills, powers of attorney, living wills. The next most popular documents, trusts. Obviously, we sort of touched upon trust inside of a will. Those are called testamentary trusts. There's also trust, standalone trust outside of will, trust that you make up during your lifetime, inter vivos trust they're called. And those can be used for several different reasons also. Again, additional estate tax planning reasons, control reasons, living trusts might be used, again, for a couple reasons. One, to avoid what they call probate, and two, just to help facilitate the management of assets. In other words, maybe a client's elderly, and instead of owning the assets in their own name, they own them inside of a living trust. The living trust will be very flexible towards that client. In other words, the trustee can distribute money to that person whenever that person needs it, and the trustee would have full control. So if the elderly client starts to have trouble managing his or her own affairs, maybe the child who's the trustee, or whomever the person would like, whoever they appoint as trustee, can help sort of manage their assets.
We've talked about the different documents that are available and what people should have in place. One of the things that's kind of interesting is that assets, from what I've studied and what I've dealt with finance over the years, don't always pass by will. They pass by ownership. How do you own them? How do you name beneficiaries? And a lot of times there's conflict, and what is said in a will doesn't always happen. Maybe you can take a little bit of time with us and just talk about coordinating the will with some of the other things that you have going on in your financial life.
Sure. I mean, I think that's probably the biggest miss of all these things, and I think there's a lot of misses here when people work on their estate planning, and this is the biggest by far. What you're saying is, not all assets pass pursuant to your will. So you have jointly held assets that pass pursuant to the law, which says that they pass to the surviving joint tenants. You have life insurance, which passes pursuant to a beneficiary designation. You have retirement plan assets, which pass pursuant to beneficiary designations. And the big problem occurs when a client has an intent that's laid out maybe in their will. Okay, for example, I want to make sure my children don't inherit at 18. I want to make sure that they have to wait till they're 30 or 35 before they control their inheritance. And then the beneficiary of their life insurance policy is the child. The insurance company doesn't really care that your will says, I didn't want the child to get money until they were 30 or 35. The child's named as the beneficiary, and the insurance company is going to write that child a check. And they're going to have control over that at age 18. Maybe you have jointly held assets where a husband and a wife own their assets jointly, and the intent there is for the one spouse to maintain some control over the surviving spouse for the issues that we touched upon earlier, protecting a child from a previous marriage, or protecting their spouse against a future divorce, right, should they die. And the idea is, all right, I want to get all these assets in a trust for the benefit of my spouse to protect against all these problems. But again, you own all your assets jointly. Your spouse is named as the beneficiary of your life insurance policy. And again, everything's going to end up outright in the hands of a spouse, even though that's not the intent. So coordination of beneficiary designations with life insurance, with retirement plan assets, and asset ownership. How are your assets titled? Should they be owned jointly, or should they be in one person's name or another person's name, or held as what they call tenants in common? Is a big discussion to be had, and it gets overlooked, I would say, almost 100% of the time.
What's interesting is when you say that I would imagine that people that do their own will, or they just get a simple will done somewhere, that conversation of coordination and titling of assets and beneficiary arrangements to make sure that it all comes together, that's probably the biggest gap that isn't occurring, and where people are really getting hurt and their estate plan just doesn't function. It just doesn't do what the intention is.
That's absolutely right. I mean, I would almost say 100% of the time there's no conversation around that. We'll have clients that come in, and maybe they have $2-3 million of life insurance, and and I say, okay, well, who's the beneficiary? And so, you know, my wife, and then if she's not alive, my kids. And the kids are young.
Right.
So, you know, the person that sold you that insurance not tell you that you're, you know, God forbid something happens to you and your wife, that your kids are going to get a check at age 18? Is that, you know, is that the intent? No, it's not my intent.
But that was the plan.
Right, that's right. So, yeah, I do. I think that's missed all the time, every time.
Very good. The last thing I'd like to hit on with you a little bit, Mike, is that, you know, from time to time I'll meet with a client, you know, and I'll ask them, you know, if we could take a look at their documents, and they take out the document, and I look and I goes like, wow, this thing was never even opened. It's still in the envelope from 20 years ago.
Right.
So the question is how often should documents be reviewed? And, you know, what should people be looking at as it relates to reviews and things of that nature?
Yeah, I mean, there's a lot of things that could occur that would cause a client to want to change his or her documents. One, a change in the law. That would be a big reason to change the documents. And I think
that happens pretty often.
It happens all the time now. And I think that's on the attorney to stay in contact with their clients and to alert them of a law change. For example, you know, we just had the last tax law was set to expire in January of 2011. As you touched upon earlier, we got a 2-year extension with some new different rules within that 2-year period. And, you know, because of that, I sent a letter to all my clients saying, you know, we got a new little law here. You know, we should sit down and talk about how this might affect your planning. So I think that's on the attorney, any tax law changes. Any family changes, you know, sometimes I'll sit down with clients, they have their old wills, and, you know, they name their brother as the executor, and I'm like, I don't even talk to my brother anymore, you know, and they're the executor of the document. As far on the beneficiary side, what we were talking about before, it happens all the time. I'm with a young couple, maybe they're, you know, 35, 40 years old, and they've been working at their job for 15 years, and their mom is the beneficiary of their 401k plan at work because they never sort of took a look at anything and updated. We just saw that one. Yeah, so you know, that happens all the time. Change in family situation. You know, married, kids. You know, that's a reason to look at things. Kids getting older. You know, maybe when your kid was 10, they weren't going to be named the executor of your will, but, you know, now your kid's 30 or 40 or 50. You know, maybe it might be time to get rid of your brother or your mother as the executor and name your child. Changes in finance. You know, obviously, you know, the tax planning that's been done previous might be different if, you know, if you're talking about different numbers. So a lot of reasons that you might want to look at that, and then simple passage of time. I mean, I think it's probably a good idea, you know, a maximum of every 5 years to at least take a look and make sure that sort of things are still current.
Very good. Well, Mike, it sounds like, in just summarizing everything, you know, that, you know, first issue that we're looking at as it relates to the estate planning and when they're sitting down with someone like yourself is the intent.
Yep.
You know, what are the intentions? Identifying from the tax standpoint of what could we do or what can be done from a tax standpoint to minimize taxes. Then we get into the control issues with regard to how are these assets get managed, you know, what's going to happen with them. We talk about distribution as far as how that's, you know, coordinating. And then the last couple of ones are really just making sure that you have all the proper documents based upon your goals and objectives, and then making sure that they're kept in coordination with everything else with regard to beneficiary arrangements, and that everything is coordinated, you know, so that it happens. And then just making sure no later than every 5 years that it's being reviewed, because things change.
That's right.
Whether it's your intent or the tax law that changes, things do change. So
absolutely.
We thank you for the time that you spent with us today.
My pleasure. Thank you.
It's always a pleasure, Michael. Yeah. So great. And thank you, everybody. Have a great day.